We need to talk about something that's happening inside British courts right now that barely anybody knows about. Your right to trial by jury, the cornerstone of the British democracy, that is being slowly eroded. Let's start with the basics. A jury trial means 12 ordinary people, chosen at random, listen to the evidence and decide whether you're guilty or innocent. The judge controls the law, but the jury controls the verdict. That is important because it places at least one part of the justice system outside of the state's direct control. It is a small piece of democracy inside of an otherwise very hierarchical looking machine. Over the last 25 years, governments from both parties have slowly chipped away at this space. In the year 2000, the Home Secretary under Tony Blair's New Labour government, Jack Straw, introduced the Criminal Justice Bill. These were early proposals to limit jury trials, and they were framed as cost-effective and efficient. In 2003, the Criminal Justice Act is passed under Tony Blair's Labour, and it introduced non-jury trials. This was the first major legislative erosion in modern times. The framing was always the same. Public safety, very reasonable, very emergency, very effective. This was brought into force by 2007. During the Gordon Brown era, the government quietly explored digital case management systems that made juries less necessary. They ended up not progressing that because the political cost was so high. From 2010 to 2020, consecutive Conservative governments continuously floated ideas of removing juries. They suggested judge-only trials for complex fraud. They suggested expansion of either way offences. They suggested expansion of virtual trials through austerity and pandemic measures, all while cutting legal aid and closing courts. Austerity was used to pressure the system away from full jury trials. The Coronavirus Act of 2020 used emergency powers to move to remote hearings. At this point, courts do realise that it is more convenient to manage this system digitally, so human beings on a jury don't have to come into court. Fine. The problem is, instead of digitising the jury, they used pandemic powers to normalise automatic non-jury systems. Not because of coronavirus, but because of administrative convenience. Governments from both parties have consistently tested the water for the removal of juries over the last 20 years. And both parties consistently have said that this is needed because of cost, speed, efficiency. But mostly it's just political control over the justice system. This year, David Lammy, the Justice Secretary, leaked a memo. His proposal was to restrict juries to homicide and rape only. Everything else, theft, assault, fraud, violence, sexual assault, that can either go to a one lone judge or a judge with magistrates. That is a 95% reduction in jury trials. Labour's legal policy signals in 2023 and 2024 included a commitment to fast-tracking serious cases. This creates pressure to streamline trials. The Ministry of Defence repeatedly frames juries as a bottleneck. Labour have signalled an interest in specialist courts. Specialist courts tend to reduce jury use. So fraud courts, domestic violence courts, sexual offences courts being led by a judge or maybe a panel. But the biggest legal policy signal that Labour have given is that they want to expand digital justice. So AI-supported case triage, online plea portals, expansion of remote procedural hearings. Some of this stuff makes sense, but not in the way Labour are doing it. Let's talk about digital justice because it's not just one thing. It's a collection of tools being deployed across a huge system, each with its own incentive. Case management systems have already been digitised. That enables centralised files, evidence and scheduling. But it removes the defence prosecution parity because the Crown controls the platform architecture. Video hearings are already used, and this is certainly cheaper than doing it in person. Online plea portals encourage early pleas for minor offences. This is moving some cases out of contested trial pipelines. But then we get to algorithmic triage. This is where AI is risk scoring, workload forecasting and disclosure sorting. The problem is these algorithms are being built by private contractors under opaque procurement. Digitisation can be good. Obviously, online hearings are useful. But the more we digitise, the more power shifts centrally. More justice is flowing through software. More decisions happen outside of court. More procedural steps are automated, templated, or pre-filled. More defendants interact with systems without lawyers. And the more the state gains procedural control of justice. Power is moving upwards and in. Digital justice is not neutral. These design choices are attempting to tilt bureaucratic control. Why are juries not being built into the digital systems? It's not because they cannot be digital. Labour would tell you it's because juries are slow. Juries are more expensive. Juries increase uncertainty for prosecutors. What they don't say, what they don't like, is that juries depend on citizens. They cannot be run by state employees or contracted software. They require public scrutiny. From a Treasury or Ministry of Justice perspective, a digital justice system that still relies on jury trials undermines the efficiency argument being used to justify the digitisation. So the infrastructure of digital justice is being deliberately built around a non-jury workflow. The government will say this is about efficiency and money. They're right, but they're hiding the real problem. A judge sitting alone is predictable. A jury is not. Juries acquit people that the Crown thinks are guilty. They will return not guilty because of conscience. Recently, Extinction Rebellion protesters were acquitted in spite of evidence because a jury found that the case was unjust. Juries are a direct check on state power. A judge is a state employee. A magistrate is a state employee. They work from process, precedent, and the law. They don't have to have a conscience in that same way. They don't have the permission to. So when the Ministry of Justice talks about efficiency, what they mean is we want cases processed faster, cheaper, and with less uncertainty about the outcome. It's the jury that stands between you and the machinery of the empire. Understand that this is happening. It is slow, bureaucratic enclosure of your rights. You have the right to be judged by your peers, to have a group of ordinary people decide on your innocence or guilt. Juries are a check on power, not a relic. To remove them in the name of government efficiency is raw neoliberal bullshit. There are civil liberties organisations fighting this, including the Bar Council and the Law Society. You need to understand that this is happening. It's not a conspiracy. If you live in Britain, your rights are being eroded and you need to fight for them. I will be posting later today on allymacforever.substack.com with broader civic action points. We do not need to erode your human rights and civil liberties to save the justice system from bankruptcy. David Lammy is on some bullshit. Like, comment, share, subscribe.